Okay, today we're going to talk about setting portfolio objectives and a couple of other topics. In particular, we're going to start off by talking about suitability versus fiduciary duties and some other related topics. So this covers Chapter 3 and also Chapter 20 in the Strong textbook. Now, let me start off with a disclaimer. So it's important that you understand I am not a lawyer. I'm not even close to a lawyer. I know a few of them, but I am not a lawyer. And a big part of today's topic includes legal issues. And so just understand that I am not an expert in these areas. So what I want you to do is to take my words on these topics simply as a clue that these are things that if you're going to work with clients, you need to be aware of these things. And in particular, what you need to be aware of is that the law is changing fairly rapidly. So, for example, just last month, at the end of June 2020, we had Regulation Best Interest took place, which affects the things that we're talking about here today. So I want you to be aware of these topics. I'm not an expert in them. You don't have to be an expert in them at this point. But just understand that these are important topics. Now, in particular, with respect to this class, remember that you have the Stock Track project. And in the Stock Track project, you are going to be managing a portfolio for a client. When you determine the goals, the objectives for that portfolio, and as you manage that portfolio throughout the semester, you need to be considering these topics, the idea that you are a fiduciary for your client as you go through the semester. So prior to 2010 or so, I don't recall the exact date, both the New York Stock Exchange and the NASD had rules. They had their own enforcement arms, and a couple of these rules involved know your customer and suitability. Both the NASD and the New York Stock Exchange had their own rules on these things, but they merged their enforcement divisions into something known as FINRA. FINRA stands for, or did stand for, the Financial Industry Regulatory Authority. I believe these days it's just FINRA, and it supposedly doesn't stand for anything, but that's originally what it stood for. And as of 2012, FINRA created two rules. Rule 2090 requires that investment professionals know their customers, or these are what are known as KYC rules. And FINRA Rule 2111 applies to brokers, and it requires that the investment recommendations be suitable for the client. Now, an investment advisor, and I'm using that term in the broadest possible way. This could be a stockbroker, a financial planner, a registered investment advisor, and so on. They may, and in many cases they absolutely do, have a fiduciary duty to their client. Now, we'll talk about fiduciary duties in more detail here in a few minutes, but just understand that this basically means that you must act in the absolute best interest of your client, regardless of your own interests. Now, brokers in particular, and understand what a broker is. A broker is simply some kind of intermediary that brings together buyers and sellers. That's it. A registered investment advisor or a financial planner works with their client to create an appropriate portfolio. So the broker's job is simply to bring together buyers and sellers. In other words, to transact in this case, investments. But investment advisors, of which financial planners could be considered one, help the client to build a portfolio of appropriate investments. So while stockbrokers may give some investment advice, they probably are not held to this fiduciary standard, or at least they weren't prior to very recently. In January of 2011, and this is following the financial crisis of 2009, the SEC released a report that recommended that stockbrokers be held to the fiduciary standard so that they would be regulated in the same way as registered investment advisors. Now, you can imagine at the time this created kind of an uproar The financial planners and registered investment advisors were all in favor of it because they had been for some time held to a stricter standard. But brokers were against it. In any case, nothing much happened until fairly recently, and we'll talk about that. Now, FINRA Rule 2111 applies not just to specific security advice, this is the suitability rule, but also to any kind of recommended investment strategies. Now, in order to execute this duty, the advisor must understand the client's needs and their desires and help the client turn those into a coherent set of objectives. And the primary way that they do this, at least initially, is by compiling what's known as an investor profile. And so this is going to include a number of things, including the investor's age, what other investments they have, their financial situation, their tax status, investment objectives, their experience, their time horizon, their need for liquidity, and of course their risk tolerance. This was a significant upgrade from the old rules from the New York Stock Exchange and the NASD. Now let's talk about what a fiduciary is. So again, the fiduciary's job is to act in the best interest of the principal. So we have a principal and agent relationship. Remember that the agent works for the principal. And if an agent has a fiduciary duty, then they must at all times act in the best interest of the principal rather than serving their own interests. The fiduciary duty is the highest standard of care under the law. And these duties include, first of all, and I got this list from a law dictionary some years ago. And again, I'm no expert on this. Ultimately, the courts will decide whether a fiduciary has violated his or her duties or not. So just understand that this is kind of a summary of the fiduciary duty. So the first one is utmost care. So the agent is bound to the highest standard of a professional in the field, which means they have a duty to investigate within the means of the profession to ensure the maximum protection and information be provided to the principal. Next is integrity. So this is soundness of moral principle and character. Honesty and full disclosure of all material facts, either known or knowable by the agent, which could influence in any way the principal's decisions, actions, or willingness to enter into a transaction. Loyalty. This is an obligation to refrain from acquiring any interest adverse to that of the principal without full and complete disclosure and obtaining the principal's informed consent. And then finally, we have the duty of good faith, which includes total truthfulness, absolute integrity, and total fidelity to the principal's interest. This prohibits any advantage over the principal obtained by the slightest misrepresentation, concealment, threat, or adverse pressure of any kind. So what you should take from this is that the fiduciary has as an obligation under the law the duty to serve in the absolute best interests of the client regardless of their own interests. Now, we've already established, and we'll talk about this a little bit more, but brokers are not generally fiduciaries, or at least they haven't been in the past. But what about CFPs? This is the Certified Financial Planner, and we're going to focus primarily on those that have the Certified Financial Planner designation. So in this case, the CFP board is very important because they set the standards. So are CFPs fiduciaries? Well, the answer to that is probably or almost certainly. Now, it does depend on the circumstances, and in particular, it depends on whether the CFP has access to client assets. So, in the 2019 revision of the CFP board's standards of conduct, they had this to say. First of all, they said at all times when providing financial advice to a client, a CFP professional must act as a fiduciary and therefore act in the best interest of the client. The following duties must be fulfilled. So there's a duty of loyalty, which means that they place the interests of the client above that of the professional and the professional's firm. They avoid conflicts of interest, or they fully disclose material conflicts. Material means important. And they obtain the client's informed consent and properly manage the conflict. And they act without regard to the financial or other interests of the professional the professional's firm, or any individual other than the client. They have a duty of care, so they must act with the care, skill, prudence, and diligence that a prudent professional would exercise in light of the client's goals, risk tolerance, etc. And this is at least partly why education is such an important part of the CFP designation. This is partly why they have an obligation to do continuing education. And then they have a duty to follow client instructions, so they must comply with all objectives, policies, restrictions, etc. And they go on to say that a financial planning practitioner shall act in the interests of the client. So this sounds a lot like a fiduciary duty as I defined it earlier. And this means that the CFP board considers all CFPs to be fiduciaries when they are providing financial planning services. However, it's possible that there may be other services that they provide where they may not be held as a fiduciary. But if you get the CFP designation, the best idea is to just assume at all times that you are in fact operating as a fiduciary, regardless of anything else. Now, here's a little bit more from the Code of Ethics. So they say that CFPs must act with honesty, integrity, competence, and diligence, act in the client's best interest, exercise due care, avoid or disclose and manage conflicts of interest, maintain the confidentiality and protect the privacy of client information, act in a manner that reflects positively on the financial planning profession. And so, to me, that sounds a lot like that legal definition that I gave of a fiduciary earlier. So I think it's safe to assume that the courts, which are the ultimate arbiters of this question, will say that a CFP is in fact a fiduciary. Now, one other point, courts may sometimes use something known as shingle theory, which basically means if you hold yourself out as a financial planning professional, then you're signaling that your conduct and qualifications meet certain standards and professional norms. In other words, even if you're not a designated CFP, the courts may find that you are responsible for acting as a fiduciary. Now, I mentioned earlier that brokers have historically been held to this suitability standard. So what is suitability? Well, basically it means that you can only recommend investments that are suitable for your client. Part of the problem, though, is that there's no statute that defines what is suitable. So let's think about some important considerations. First of all, you need to consider the client's financial situation. Also, what they have in their current investment portfolio, their need for current income, their tax status, their investment objectives, and their risk tolerance. The way that brokers and financial planners and others get at these questions generally is by providing questionnaires. So I've posted on Canvas a few examples from Charles Schwab and others to give you an idea of what these documents look like. Also, I've posted up there a spreadsheet that I created some years ago from a document that Northern Trust put out. And basically, it is a risk tolerance questionnaire that helps to determine what an appropriate asset allocation would be. I encourage you to take a look at that spreadsheet and work through it, perhaps with your client in mind, but realize that the asset allocations came from a number of years ago, and Northern Trust might have different asset allocations these days. This slide simply tells about the differences between brokerage and advisory accounts. We've already talked about this a little bit. I encourage you to read this slide, but I'm not really going to talk about it here today. Now, new on the scene is a regulation referred to as Reg BI. That stands for best interest. This regulation went into effect on June 30th, 2020. It was passed in 2019, in the early fall of 2019. And it basically increases the standard that brokers are held responsible for, from suitability to best interest. However, let me point out that financial planners and registered investment advisors are not happy about this because it's a little bit less than a full fiduciary standard for brokers. So after the 2009 financial crisis, Congress passed something known as the Dodd-Frank Wall Street Reform and Consumer Protection Act. And as part of that act, they encouraged the SEC to impose a fiduciary standard on brokers. Ever since, there have been major arguments. The SEC basically did nothing for a long time. The Labor Department passed a regulation that required a fiduciary standard as of 2017 for anyone giving advice on retirement accounts. That would be 401ks, rollovers from IRAs, and etc. That regulation was overturned by the courts in 2018. But since Reg BI was passed, the Labor Department has come back with a revised version of that. In any case, let's talk about a little bit about Reg BI. So this regulation, first of all, it upgraded the broker's duty from suitability to best interest, and this has been referred to as a quasi-fiduciary standard. Quasi means essentially that it's not quite a full fiduciary standard, but it's a lot closer than what we had before. It requires full and fair disclosure, requires brokers to exercise reasonable diligence, care, and skill when they make recommendations, minimizes conflicts of interest, and it requires brokerage firms to establish, maintain, and enforce written policies and procedures to achieve compliance with this act. So basically what this means is that these days, brokers are held to a higher standard than they used to be. Still not quite a full fiduciary standard, but presumably better than it was before. Now, all of this is brand new. The courts haven't yet sorted this out. Regulation BI may or may not have a big impact on the brokerage business. Understand, too, that after 2010 or so, after the Dodd-Frank law was passed, a lot of brokerage firms retooled and basically started acting more like fiduciaries. Maybe not completely, but more like fiduciaries. So probably Reg BI is not going to, in the short term, have a huge impact, would be my guess. Now, let's talk a little bit about the history of this. So in 1830, there was a court case in Massachusetts that established something that came to be known as the prudent man rule. And this said that trustees should observe how men of prudence, discretion, and intelligence manage their own affairs, not in regard to speculation, but in regard to the permanent, that is long-term, disposition of their funds, considering the probable income as well as the probable safety of the capital to be invested. In other words, a trustee had to manage the money of their client in a way that's similar to what they would do with their own money. Now, this was a very strict standard, and it required that each and every investment on its own be suitable for the investor. In other words, speculative investments must be avoided. And for a very long time, this was interpreted to basically mean only fixed income, safe fixed income assets were appropriate in trust accounts. This took no account of the idea of diversification, and the law has since evolved to more of a whole portfolio standard. So instead of looking at each individual asset, now we look at whole portfolios. The Uniform Prudent Investor Act was an update of the Prudent Man Rule, and this was written in the early 1990s and has since been adopted by most, if not all, states. And essentially what it does is it says, look, we now know about diversification, and so we should consider the portfolio as a whole rather than looking at individual investments. So the major differences from the Prudent Man Rule are that the entire investment portfolio is considered, diversification is explicitly required as a duty for a fiduciary, and no category or type of investment is deemed inherently imprudent. Let me give you an example. Writing covered calls is known to be a very safe form of investment. The way a covered call works is you buy a stock and then you sell short a call option against that stock. You get income for doing that, and the worst thing that can happen is that the stock gets called away from you. And so generally speaking, you might give up a little bit of capital gain, but you receive some income from doing that. And generally speaking, a covered call is considered to be safer than just owning the underlying stock itself. But under the Prudent Man Rule, options were considered to be dangerous. And so a covered call strategy would probably have been considered a violation of the fiduciary duty. Under the Uniform Prudent Investor Act, that's no longer the case. Also, the Uniform Prudent Investor Act allows the investment manager to delegate some functions to third parties. Okay, let's talk about the process that a financial advisor goes through. So first of all, they need to evaluate the client's, and I'm assuming a new client here, but they need to evaluate the client's current portfolio. What do they currently own? They also need to determine the financial needs of the client, and they can do that through a questionnaire. Determine the risk tolerance of the client, and again, that can be part of the same questionnaire. And again, there are examples up on Canvas for you to take a look at. Once they've done that, once they've determined the financial needs and the risk tolerance, they can set the objectives for the portfolio, and that's what we're going to talk about here in a second. Then they can remake the current portfolio to match the objectives. Once they've done that, they manage and monitor the portfolio, and then finally return back to step one. So again, they start over. So maybe every 6 months or once a year or whatever the time frame is, they go through this process again. So they evaluate the portfolio, try to determine if it's meeting the client's needs, see if those needs have been updated, has the risk tolerance changed. There's all kinds of things that occur in life that might change the financial needs and the risk tolerance, and the portfolio needs to be constantly updated so that it meets the current needs and the current risk tolerance. So this process is not one and done. It has to be continually cycled through. Okay, so let's talk about portfolio objectives. So first of all, the purpose of an investment portfolio is to meet the needs, either future or present, of the client and or beneficiaries with an appropriate level of risk. Now, one of the things that we're going to spend a fair amount of time this semester talking about is balancing risk and return. So in your investments class, you probably, maybe not, but you probably got the idea that investing is all about returns. But if you try to maximize returns at all times, you're probably going to end up taking huge amounts of risk that are not appropriate. And so we need to balance risk and return. So keep in mind that the objectives must meet the needs of both current and future beneficiaries, and that sometimes the client will be one person, and other times it may be multiple people. So you can imagine somebody with a retirement account, the client is that one person. That account is there to meet their future needs. On the other hand, a pension fund is built to meet the needs of many people in the future. So these are the beneficiaries. And the beneficiaries in some cases may be people who haven't even been born yet. Now, the portfolio objectives will help to determine the investment policy, which we'll talk about in Chapter 4, and the strategies used to meet the objectives. So your author gives us 4 possible portfolio objectives. I'm going to add another one, may or may not be terribly relevant. So stability of principal. We'll talk about each of these as we go, but in essence, this means you cannot afford to lose any of the principal. Income, which means you want to generate income from the portfolio. Growth of income. Capital appreciation. Those are the 4 that your author, Strong, defines. And then I like to add speculation, because in particular, a lot of times people like to have a small part of their portfolio that they use for very risky investments. So rarely would speculation be the main portfolio objective. So let's go through these one at a time. So stability of the principal is the least risky of all of the possible objectives. Stability of principal is an appropriate objective for a client or beneficiary who cannot afford to lose even a tiny amount of the principal. So this is generally not suitable for individual investors. Instead, it's most suited to endowment funds who have a mandate. Whoever gave the money to the endowment said, look, you cannot lose any of this money, and you have to operate from the income that it generates. It might be appropriate for certain individual investors that have a very short-term goal. So for example, with part of your portfolio, maybe you're saving to make a down payment on a house in a year or 2 or 3. So you might want to operate that portion of your portfolio with a stability of principal goal in mind. You need to make sure that the client understands that they are not going to make a lot of money this way. Particularly today, with interest rates being so very low, the income generated will be almost nothing. And so safety is ultimately what this is all about. We don't want to lose anything. And therefore, the allowed investments basically are government guaranteed investments such as treasury bills, certificates of deposit, and any other strongly guaranteed investment. Now, let me point out that I said treasury bills. I did not say treasury notes or treasury bonds or any other kind of long-term bond, because those will have values that fluctuate over time. So you could, depending on when you sell, you could lose money on a treasury bond. With a treasury bill, I suppose you could lose some money if you sell before it matures, but that's unusual. And remember that treasury bills are very short-term investments, less than 1 year in original maturity. So it's unlikely that you would lose money on a treasury bill, and the interest is guaranteed by the government. The income objective allows for a little bit of risk, but it's still going to be very low risk, because you have to remember, if you lose the principal, you're going to get less or possibly no income. This objective is appropriate for beneficiaries who need to live on the income generated by the portfolio. Suitable investments here would include treasury securities, even longer term ones, right? Because we can take a little bit of risk. Municipal securities, highly rated corporate bonds, and maybe just a touch of high quality dividend paying stocks. Now, growth of income is a little bit different than income, because we not only want the income, but we need the income to grow over time, particularly to keep up with inflation, but maybe even more than that. So in order to generate this growing stream of income, you have to take a little bit more risk. And that means that some of the income that you're generating now probably will have to be reinvested, or you're going to have to take on riskier securities. So all of the previous investments that we've mentioned are appropriate here, but also you're probably going to allocate more money, maybe not a lot, but more money to long-term bonds and common stocks. Capital appreciation objective is all about growing the principal, not generating income. And often this is called a growth objective as opposed to capital appreciation. Of the four that we've looked at, this is the most risky. Doesn't mean that it has to be very risky, but just that it's more risky than, say, an income objective. So this is going to be appropriate for investors that have little or no need for income from their investments. So somebody saving for retirement 10, 20, 30 years from now probably has a capital appreciation objective. So suitable investments here would include all of the ones that we've talked about previously, but a much higher allocation to common stocks, because that's generally where growth is going to come from, the price appreciation of the stocks. And this could include some more risky stocks like small company stocks or even highly speculative stocks. Now, finally, the objective that I've added here is speculation. So speculation generally, I think, to most people means high-risk activities. These are investments that have a very high chance of not paying off, but if they work out as hoped, the payoff could be huge. This generally, almost never, would be the primary objective of an investor. Instead, we sometimes take what we'll talk about in a second called a portfolio splitting approach, where we might saw off a tiny portion, maybe 5% of the portfolio, and invest it with a speculative objective. So we might take that 5% and put it in highly risky stocks, or we might invest in futures contracts or other such things. So suitable investments here: high growth stocks that don't pay dividends, small company stocks, options, futures, these kinds of things. Sometimes there are secondary objectives. So what we've talked about, or the way that I've framed this previously, is as primary objectives. That is the main objective of the portfolio. Often, though, we'll have other objectives as well. And so we may manage a portfolio with both primary and secondary objectives. Generally speaking, the objectives are the same, but with part of the portfolio, you invest it consistent with the next higher level objective or the next riskier objective. So a beneficiary that has an income objective might also be willing to take on a little bit more risk to provide some growth of the income over time. Or an investor seeking capital appreciation might also have a speculative portion of their portfolio. So generally speaking, the secondary objective will be somewhere between the primary objective and the next riskier objective. So for example, you would never have stability of principal and speculation as your primary and secondary objectives. That just wouldn't make any sense. Now, in other cases, the investor might be attracted to a portfolio splitting strategy, which means that we're going to basically break the portfolio into pieces and manage each piece with different objectives. But it's important to remember that in life, you get one portfolio at any given point in time. And that portfolio consists of all of the assets that you own. And so I think it's helpful to think about the portfolio as being all assets. Yes, you may manage different parts of it separately, but you need to keep in mind that this is all of the stuff that your client owns. So an endowment might have some funds that are restricted by either law or the donor's intent, but they might also have some unrestricted funds. And so they might manage those restricted funds with stability of principal in mind, but the unrestricted funds maybe are used to generate income or possibly growth of income. And this would allow the endowment to get bigger over time and give out more in grants. All right, now, finally, I want to talk about dedicated portfolios. So a dedicated portfolio is a portfolio that is set up specifically to service a set of future liabilities. So for example, an insurance company invests money so that they can pay future claims. A life insurance company invests money so that when the policyholder dies, they can afford to pay out the value of the policy. A pension fund invests money so that they can pay retirement benefits to their members in the future. And in order to do these things, they dedicate a portfolio to generate the income to meet the liabilities when they arise. So the important thing is that these portfolios generate income at an appropriate time and in appropriate amounts to meet those future liabilities when they arise. So there's several strategies that can be employed to do this. So there's cash matching, which is what we're going to talk about today, immunization, and contingent immunization. And we'll talk about these last two later on when we talk about bond portfolio management strategies. So a cash-matched portfolio is usually a fixed income portfolio because we have reliable income when we invest in fixed income products, bonds, so that we can set up a portfolio that will generate an appropriate amount of income at an appropriate time. With stocks, you generally can't do that because the dividend may be unreliable and capital gains certainly are unreliable. So generally, a dedicated portfolio is going to be a fixed income portfolio. So the simplest strategy to do this would be to purchase a bunch of zero coupon bonds with maturities that match each of the future liabilities. So let's look at a quick example. So assume that you have a pension fund that has liabilities of $100 million, $120 million, and $130 million in 5, 6, and 7 years from now. Let's assume that interest rates are 10% for simplicity. Then what we want to do is we want to buy a 5-year zero coupon bond with a face value of $100 million, a 6-year zero coupon bond with a face value of $120 million, and a 7-year zero coupon bond with a face value of $130 million. Now, understand that there may be several zero coupon bonds that are included. I'm just thinking of having only 3. But to meet that 5-year obligation, you might have a whole bunch of zero coupon bonds that mature in 5 years, but their face values add up to $100 million, and so on to meet the other liabilities. So if we have 10% interest rates, just to keep the math simple, then we could meet these obligations with $62.09 million in 5-year zeros, $67.74 million in 6-year zeros, and $66.71 million in 7-year zeros. So to get these numbers, all you have to do is find the present value of, say, $100 million in 5 years at a 10% interest rate, and you'll see that that's 62.09. Now, you could choose a selection of coupon-bearing bonds. Zero coupon bonds are easier if you can get them because they don't have any intermediate payments, and when they mature, you get that full face value. If you do this with coupon-bearing bonds, then you're going to have to reinvest the coupons, and that complicates things a little bit. Okay, so that's it for Chapter 3. And remember, this is not just Chapter 3. You also need to read Chapter 20 in Strong. And that chapter discusses fiduciary duties. So Chapter 3 is about investment objectives, and Chapter 20 is about fiduciary duties. I've combined them both into this lecture here today. Next time, we will talk about investment policy statements in Chapter 4. I'll see you then.